Continuing Avery pretrial, motion hearing, March 17th, 2006, Part 2. Attorney Kratz, yes, Mr. Gahn. The court, Mr. Gahn. Attorney Gahn, thank you, Your Honor. I'm going to rely upon the brief that I filed in response to their request to be present for the testing or, in their alternative, to have it videotaped just to amplify a few portions of that brief. Again, the defense has cited no authority or any statutory authority or case precedent to authorize them into the crime laboratory for videotaping of the procedures that go on in the crime lab. I must emphasize for the court that in a crime laboratory, especially with DNA testing, the issues of security and contamination are just of the utmost importance, and they are so very important in the accreditation process of the crime laboratory. And any time that you lessen that security or allow potential to introduce other contaminants into the crime laboratory, that's going to place that accreditation into some jeopardy. The state has cited 3 cases where that issue has come up before the appellate courts and they have ruled against the defense. I guess, Your Honor, you have to understand that what happens at the crime laboratory, we're talking about a huge number of items here of evidence. This is not just one item that is coming into the crime lab. It's just a huge number of items. When the crime lab gets these items of evidence, they're going to be screened, first of all, and that can take a couple of days. And once it's screened and they believe there may be something of potential value to submit to some type of DNA testing, that's when the extraction process takes place, and that can take also a couple of days. The problem is once extraction process is finished, the items are batched. And when that happens, other analysts may batch within this case items that they are testing for their cases. And that's what's called the quantitation. And this is a very important process, which is, again, days and days later. But once they realize how much DNA is present, whether there is a certain quantity, then the analyst, again, determine which are going to be set up for amplification process. And then you still have a number of other processes that can take 2 or 3 weeks to complete. The intrusiveness, the burdensome nature of the request would make it almost impossible for a crime lab to operate when you're looking at so many items of evidence and the process and how the analyst process takes place. The crime lab is accredited. They follow very stringent national standards, and one of the reasons for writing such a strict national standards is that the defense is given in their discovery process, and it's routinely done in Wisconsin. They're given the bench notes. They're given the protocol. They're allowed to see the quality assurance guidelines as followed, the gene scan data, the genotype RE-data. It's all designed so that an outside expert can look at the protocol, can look at the process, the analysis that was done, and determine whether it was followed so that defense is not left without anything in the case. They are open to all of the paperwork and the analytical process through the DNA typing. Having someone in trying to videotape it, again, would be so burdensome, such an order was granted. I think the court can appreciate if every defendant were allowed to have an expert to go look or videotaping could be done. You could almost shut down the crime laboratory. There are so many sensitive items that are out at the crime lab. It's evidence from cases all over the state of Wisconsin. It's a very, very sensitive issue, and security is paramount. So I'd ask the court, one of the issues I would like to address is the unnamed independent expert. I don't know what there were circumstances of this independent expert or what the circumstances were to go into an Illinois crime lab and observe. In all candor, I will admit to the court, I have heard of cases where that is done, or there's an agreement between the defense and the prosecution to send the item for independent testing. But those generally are cases where there is one critical piece of evidence and there will be total consumption of that evidence. Then you get into issues of what is materially relevant, what is potentially exculpatory evidence, and you get into an Arizona versus Youngblood analysis. That's generally where those cases come about, where it is just one piece of evidence that could be done inculpatory or it can be done exculpatory, and the defendant has no other comparable means of getting that evidence analyzed. Under those circumstances, I have heard of where the defense and the state would get together and maybe agree on an independent lab to do it, or perhaps agree upon a defense expert viewing the process. But that is rare case, and from my understanding and from my knowledge that I have. So I'd ask the court to grant our position that the defense not be allowed in to observe the testing or videotape it, mostly because of just the burdensome nature it would have upon the crime lab and security issues and just the integrity of the whole crime lab setup. Thank you, Judge. The court. Mr. Buting, anything else? Attorney Buting. Just briefly, Your Honor, as to the question of burdensome, there being so many items, I seriously doubt that in this case, because from what I understand from the prosecution, that most, if not all, of the items originally seized back in November in this case have been tested. So we're really only talking about items that are seized as a result of the most recent search warrant. And I don't think that there are that many of them that were seized. Probably a very small percentage of that when you look at it will have any area that would be worthwhile to test. So there may be only a handful, 5, 6 items perhaps, that in this case will still be tested. So I don't understand this argument that it's so burdensome because there are so many items. There's no reason those can't all be run at the same time. That would not, in fact, it would probably be the normal course. If there's one analyst working on this case, which I understand there would be. Yes, through discovery, the state does provide bench notes and the raw data, that sort of thing, which can be helpful to an expert, but it says nothing about the potential of the contamination, if cross-contamination between items of evidence. None of that can be found after the fact. That's the problem. That's why it's that very reason that the state, in order to become accredited, has to take all kinds of precautions to try and prevent that. For accreditation, some of these other labs where these problems have developed have been accredited and have thought that they were very good, sound protocols were being followed, and lo and behold, they discovered that's not the case. Finally, as to the question of whether there is, it's true that perhaps these motions are likely granted or agreements made when there is one item of evidence that will be all used up in the course of the testing. But at this point, I don't know whether that's going to be the case here or not. I don't know yet. I don't think the state knows that there is sufficient, or that there would be, if they find an area that would be worthy of searching for DNA, that it would be sufficient to guarantee a separate half of it or whatever sample for subsequent independent test. And I don't think that they are going to know until that's a number of things happen. One, they eyeball it and look at it, whether it's cloth or concrete or whatever it may be. And secondly, only after they have run it through the process to determine whether there is an amount of that's quantifiable, that's enough DNA present to try and test it further. So we may find ourselves in that situation where there is nothing left for the defense to test once the state completes its. The last point that I would ask, or I would guess maybe to make clear, that the matter of Brady demand orally, I can follow up with something in writing. In the event the court does not grant this motion, I do want to make it clear that we do consider raw data, notes, charts, and things of that matter, and the preservation of sufficient quantities of future testing to be considered Brady material that could be exculpatory, that could point to other individuals. And that would include DNA, fingerprints, all types of forensic evidence. That would also include, particularly in this case, any test results that prove positive for law enforcement DNA, which in most cases are simply discarded as erroneous mistakes. But in this case, given the history, we view as Brady material that should be preserved for subsequent review by the defense. So with that, I would ask the court to grant the motion. The court, all right. For purposes of today's hearing, I'm taking up the motion as it's been filed. I'm not going to comment on the last items that you mentioned. I'm specifically dealing with a defense request to either observe testing by the state crime lab or to have that testing videotaped. The first issue I looked at was whether or not There was a due process right on the part of the defendant to observe such testing. I actually, before I got to the state's response, looked at the New York case that's cited, that is New York versus Monigas, Monigas, which is a case that involved a request I believe precisely identical to that we have made here. And the court in that case ruled that there was not such a due process right. I have not been able to find any case that creates a constitutional right to observe testing in cases like this. And I don't understand the defense to be arguing that there is such authority. I next look at the Wisconsin statutes. We do have a statute that has been mentioned, I think, by both parties that deals with this issue, specifically section 165.79, subsection 1, that reads in the relevant part as follows: evidence, information, and analysis of evidence obtained from law enforcement officers by laboratories, and I understand it to mean state crime lab there, is privileged and not available to persons other than law enforcement officers, nor is a defendant entitled to an inspection of the information and evidence submitted to the laboratories by the state or the laboratory's findings, or to examine laboratory personnel as witnesses concerning the same prior to trial, except to the extent that the same is used by the state at the preliminary hearing, and except as provided in section 971.23. Upon request of a defendant in a felony action approved by the presiding judge, the laboratory shall conduct analyses of evidence on behalf of the defendant. No prosecuting officer is entitled to an inspection of the information or evidence submitted to the laboratories by the defendant or of the laboratory's findings, or to examine laboratory personnel as witnesses concerning the same prior to trial, except to the extent that the same is used by the accused at a preliminary hearing, except as provided in section 971.23. The statute was discussed in the case of State of Wisconsin versus Franczak, Franczczak, a 2002 Wisconsin Court of Appeals case. And in that case, the court essentially says that statute means what it says, and that is that the state crime lab performs testing on behalf of the state. It's not subject to the disclosure of discovery except as provided by the statute. And likewise, if it provides a discovery on behalf of the defendant, that the state can't get the information except in the circumstances provided for it in the statute. I'm not going to decide today whether or not there might be some special circumstances which, under the court, could grant the request made by the defense in this case. I don't see anything in the statute that expressly prohibits it, but at least the statute seems to suggest that in the ordinary course of things, absent some extenuating circumstances at minimum, the legislature doesn't contemplate the statute granting a request like this. I will also note that although there have been incidents of mistakes in other crime labs, I think anytime you are dealing with human beings, that's always a possibility. I'm not aware of our state crime lab has ever been involved in this type of thing. And as the state noted in the brief, it was actually the state's crime lab test in the defendant's prior case that resulted in him being released from prison after being wrongfully convicted, and that the state fully acknowledges that fact. So for those reasons, I don't believe there's a basis for granting the defendant's request. I'm going to deny the state's motion regarding forensic testing. Attorney Gahn, the defense motion, Your Honor. The court, the defense motion for forensic testing. I'm certainly not foreclosing the parties from coming to an agreement if they do. Anything that expedites the process and makes both parties feel assured the testing is being done properly is a benefit to all. But in absence of that, the statute seems to contemplate, as a general rule, a different approach, and therefore the court is denying the defendant's motion. The last item to deal with today is the motions that have been made by each of the parties for modification of bail in this case. The defense made its motion first, so I'll hear from the defense first. Will that be Mr. Strang or Mr. Buting? Attorney Strang. Mr. Strang. The court, Mr. Strang. We have no quarrel with today with the reasonableness of the amount of the bail set by the court here, working off of the $500,000 number. Our motion goes to the surety of the security that the court would accept as a financial condition to reasonably ensure Mr. Avery's appearance in court as he is required and the safety of the community. And what we're asking here is for the court to allow the posting of property, the tendering of a mortgage, or can be done with a quitclaim deed that then is not filed by the county clerk unless bond conditions are violated. But there are different ways to accomplish using real property as security to meet the financial aspect of the bail condition. Mr. and Mrs. Avery, who are behind me, are willing to post all of their property they own in the world, the Manitowoc County property, the Marionette County property. We have had that appraised for a fair market value. That combined unencumbered value of those properties well exceeds the $500,000 in bail that the court has set. These are solvent sureties. In other words, and Wisconsin statutes have absolutely no presumption against or bias against the use of property to secure appearance in compliance with bail conditions as opposed to cash. Real property as opposed to cash or other personality. The Corporation Counsel for the County of Manitowoc filed a letter of his own raising concerns, and I think the Corporation Counsel misapprehends the very purpose of posting property. The issue here is not what the value of Avery salvage yard or the property near Kratz might have to Manitowoc County. The issue is its fair market value, and more importantly, its value to Stephen Avery or the people he loves and care about him. The point, of course, is not for property to come to legal ownership of Manitowoc County. The point is that if he didn't follow the conditions of the bond, his parents would lose literally the farm. That's the level. That's the level that we have to assume the defendant's compliance with the conditions of release that the court sets. So without wading into DNR issues or other issues, really fundamentally, the Corporation's Counsel concerns miss the point of Chapter 969. There's no real question here that the fair market value, regardless of Manitowoc County might pay for the property, fair market value of the property well exceeds the $500,000 cash. As a practical matter, unless the court modifies bail, he is not getting out. As a practical matter, now the court knows, I know, perhaps some in the public and some in the media have forgotten that he's innocent. As he sits here today, he is legally presumed innocent. I mean, we can dress him up in something that makes him look like he, jumped off a Monopoly game board or something. He's a get out of jail free card come to life. But he is innocent as he sits here today. And he had his Thanksgiving meal as presumptively innocent man in jail. He had his Christmas meal as a presumptively innocent man in county jail. He's heading towards his Easter meal as a presumptively innocent man. And all of this delay is necessary. Nobody is recording with the delay. But the earliest, as I understand it, he's going to have a full chance to be heard and to be put to state to its burden of proof. Here to prove that, if it allows, will be after his Labor Day meal as things stand, if he is not out. 10 months is a long time to sit if you are presumptively innocent. And this is someone who was sort of sensitive about sitting in custody when he's innocent, and I understand that. He's got no history of trying to evade justice, skipping court. If anything, it's justice that once evaded him. He's lived right here in Manitowoc County all of his life, lives on his parents' property. This is not just a homestead, but it's a place on which the family's business, from which it derives its entire livelihood. He's not going to put that at risk. The reasonless perception here is that he is not going to put that risk by failing to abide by the conditions of his release. His parents would stand to lose everything if he did, as would he. I mean, it's his livelihood that has made this his property as well. The state here has relied on angry letters that he wrote to his ex-wife who divorced him while he was in prison for a crime he didn't commit. Those were written, the most recent of them, according to Judge Hazelwood, and his transcript was 15 years ago, now in 1991. They were angry, they were aggressive. His wife was trying to deprive him of any further contact with his young children. I guess I would be angry too, in his circumstance, particularly where, where I'm sitting in prison on something I didn't do, which is exactly the situation he was in at the moment. So it's not to excuse angry, aggressive, ugly letters that he wrote 15 years, 17 years, 19 years ago. It is not to put them into a context that suggests they say very, very little about today about whether he will come back to court when he's supposed to and whether he will stay in his house as he's supposed to, other than when he's conditionally allowed to leave by this court. Once we get past letters to his ex-wife, now we're into the state offering past criminal acts that are getting near quarter century old. We're getting to the state's offering convicts who only now are coming forward and saying, presumably, or at least tactically, suggesting, get me out of jail, and I will testify that this guy, talked about building torture chambers and all kinds of other stuff that inmates didn't bother to report for 15 or 18 years or whatever it's been since they heard about from Avery. This is all so much nonsense, honestly, really so much nonsense. The state has been out in search of the Avery property with consent probably 5 times or more, with search warrants at least a couple of times, it may be 3, something like that. Nobody has a torture chamber, no torture chamber on the Avery property, in the trailer he lived, or anywhere else. So it's really, some of that is beneath further comment. But that's not what the court's ability to fashion non-monetary, non-financial conditions as well. And Stephen Avery has wanted me to tell the court and invite the court to impose any other non-monetary condition that seems appropriate here, including increasing the restrictiveness of the conditions of release already set since we have moved to modify. Something Your Honor might reasonably be concerned about is if he's out of jail, are we going to be asking that he be allowed to go down to Madison to see, or down to Brookfield to see Mr. Buting? And their answer is no, we will come to him. He can be restricted to Manitowoc County. Electronic monitoring wouldn't be a bad idea, and is fully acceptable to Stephen Avery. Very controlled time out of the house or away from the property, fully acceptable to Stephen Avery. If the court wants to report in person to Two Rivers Police Department or some other law enforcement agency on a regular cycle, fully acceptable to Mr. Avery. And of course, I would expect that in the process of posting real property to secure the bail that the court has set, that the state would want to look at the appraisals, want to look at the title and any encumbrance to it. And I'm wholly prepared to share all that information with the state. Indeed, the Averys, the senior Averys, have gone to the trouble of retaining Mr. Kranjek, a local lawyer who here does real estate work, to assist in assembling of the information that would be necessary to secure bail with real estate rather than cash. So that's our request here today. I know the state has a competing motion, but perhaps it's better in my place to respond to the state's argument in that respect. The court. All right, Mr. Kratz. Attorney Kratz. Thank you, Judge. Mr. Strang is correct. The state does have a competing motion that we filed. Actually, the other side of Mr. Strang's motion, the other side of the coin, if you will, is our second motion. That is our motion to increase cash bail. Now, I'm going to take this opportunity then to first argue that, since it addresses the same factors that Mr. Strang has argued. The state no longer believes that a $500,000 cash bond is appropriate. The court may recall that the state originally requested a $1 million cash bond to secure Mr. Avery's future court appearances, but this court can, and I believe should, take into consideration new factors, that is, what we have learned since that last time we addressed bond. Since the last time I was before the court and addressed bond, substantial changes have occurred in this case. Now Mr. Strang can sit here and presume Mr. Avery to be innocent. I don't have to do that. And when I make these arguments to the court, statute 969.01, section 4, is on the state's side that regard when it invites, in fact, requires the court consider the character and strength of the state's case. Now, the character and strength of the case against Stephen Avery, I will argue, has changed dramatically since we last visited this issue. The detailed statements given by what I'm calling the co-actor, the co-perpetrator in this case, speak directly to the nature, number, and gravity of offenses, and to leave bond at the previously issued, I believe, does a disservice not only to this particular case, but does not reflect Mr. Avery's likelihood of appearing in future court appearances. There are other factors that I previously argued, including the degree of violence used. There is new information as to those. I had already argued the prior criminal record, the fact that other crimes had been committed while Mr. Avery was out on legal status, that he's now been bound over for trial. New information through our request to increase cash bail to $2 million includes the allegations of his plans to flee the jurisdiction. The alternatives to cash bail not being warranted, as cited by the Manitowoc County Corp Counsel, and what I'm arguing is one of the most important factors, that is Mr. Avery's character. Those items contained in the affidavit, an affidavit, something more than mere allegations, but something contemplated by the motion practice in the state of Wisconsin, sets forth some specific acts of violence, some specific plans for Mr. Avery that I think are very important as to the state's request for increased cash bail. And therefore, I make the request, Your Honor, to raise cash bail, to deny any kind of surety or property bond, and to increase cash bail previously authorized to $2 million. I am prepared, Judge, although, as I mentioned, included a formal detailed motion and affidavit to argue the denial of bail. But I didn't know if the court wanted to address the first motion or what I have characterized as the other side of Mr. Strang's motion first. But I am prepared to proceed, Your Honor. The court, with respect to the motion to deny bail, that's a request that has not been made to me before in another case. But as I read the statute, I reread it this morning. I believe it involves a testimonial hearing, an evidentiary hearing with fairly extensive description. It involves essentially a mini trial. Attorney Kratz, it does, Judge, and that's why I have stopped. I have the witnesses. I have the officers prepared for that. I don't know how much time the court has set aside for that. Let me also indicate, depending on how the court and Mr. Strang wants to proceed, it may even contemplate calling other witnesses or providing writs or the like for what the court calls a mini trial. I don't disagree with the procedure as contemplated in the statute. That's why I'm stopping at this point, and I think asking the court to rule on Mr. Strang and my motion. Frankly, Judge, depending on that motion, the state may ask in another matter to be heard on the denial motion. The court, Mr. Strang, I'm looking now for your response to that motion to increase cash bail. I'm not seeking comment on the motion to deny bail. Attorney Strang, okay, a lot of this is so academic that one wonders why the state wants to talk about it. The original charges, the first one carries a mandatory life sentence, and then we've got 12 and a half years of possible confinement on one charge beyond that. And I haven't even looked recently in 7 years or 5 years or something on the other one. But once you are at mandatory life, adding more exposure really doesn't alter the calculus much for a defendant in deciding whether he's going to stick around or to try to make a run for it. In terms of proclivities, boy, I didn't notice much in my television back in the early November, but any inclination of him to avoid anybody, a camera, a police officers, he's consenting to searches. He's talking to anybody who wants to search him. He's going up to his family's cottage, to be sure, a cottage they have had for decades up in Kratz. Everybody knows where he is. There's nothing here, not only in the lead up to his arrest, but in his earlier cases suggests that he tries to run away, avoid obligations to come to court. There's just nothing, not a bench warrant, as far as I know, at least nothing the state has tendered to the court. So, and adding, we could add 100 more charges here if creative counsel wanted to do that. And it wouldn't really change the functional incentives that have been in place since he was charged with the first degree intentional homicide count. Beyond that, I note under our statute, specifically 969.08, Section 5, it is a little bit ambiguous here. If you're out on release and the state alleged that he violated conditions of release and wanted to tighten up or add conditions to address a violation of conditions of release once he's out, if that were the state's request, we would be entitled to a hearing, and the state would bear the burden of proof by clear and convincing evidence in establishing both the violation and the need for some tighter conditions. Now, it is ambiguous because one also can read the same statutes, 969.081 or 5, as allowing the court on the state's motion to increase conditions of bail. So I'm not hanging my hat, so to speak, on this entirely, but it's passing strange to say that if you were out, increasing cash from $500,000 to $2 million as a response to some violation of conditional release would entitle me to a hearing at which there's an intermediate standard of proof. But when he is not out and has no realistic prospect of posting $500,000 in cash, that's not happened. Would have happened by now if there were anywhere within the realm of possibility that the state, with no showing other than statements of inmates or 20-year-old allegations being filtered through a law enforcement officer's affidavit now, can quadruple the amount of bail that the court is being asked to set. The court. Anything else, Mr. Kratz? Attorney Kratz. No, not on this issue, Judge. Thank you. The court. Now, I'm going to take a brief recess. I have my notes from the prior bail hearing in chambers. I'm going to look at them and then I'll come back. Attorney Buting, Your Honor, could we deal with that issue of recess with regard to the cameras and filming at this time if we're going to break the proceedings? The court. Yes, for the purpose of today's hearing, I'm going to ask the camera folks to shut down during recess. The court proceedings aren't going on during that time, and the parties are entitled to speak with each other privately during that time. Attorney Buting, thank you. Recess taken. The court, I did take the opportunity to go back and review my notes from the last bail modification motion hearing. I'm not going to repeat all the findings and matters I relied on at the time because of the fact that the defense in this case is not disputing the current level of bail of $500,000. But I think it's worthwhile to review the things that have changed since our last bail modification hearing as I view them. I will note that, based on the court's decision today, the court has allowed for filing of additional charges against the defendant. The number and gravity of the offenses are greater, as are the penalties that the defendant faces, though, as noted by defense counsel, the penalties under the existing charges are already significant. The court further notes that the level of violence alleged in the complaint is greater than it was before, based on the new allegations. And the court, while keeping in mind that the defendant is innocent until proven guilty, and the court makes no comment on what the final disposition in this case might be, a jury will obviously make that determination. But the statutes do direct the court to take into consideration in setting bail the strength of the evidence that has been presented, and is no longer purely a circumstantial evidence case based on the new allegations made by the state. And the court would have to characterize the strength of the evidence at this point as greater than it had been in the past. The state has also alleged that the statement on behalf of the defendant that at one point in the proceeding before his initial appearance, he considered flight. I think that that's not as stated. It's not an unequivocal statement. It may reflect just one defendant's thought at the time. There's no evidence that he's actually tried to flee the jurisdiction or anything like that, but it was made at a time before the charges were actually filed, and to the extent the defendant would ever have considered flight, the reasons would be greater at this stage than in the past. Finally, although it may not be the most significant consideration, based on the fact that the defendant has now retained private counsel, is not represented by a public defender's office, the court has been informed that as a result of that settlement of a lawsuit, the defendant's ability to give bail is somewhat greater than it has been in the past. Taking those factors into account, the court believes that the bail in this case should be increased from $500,000 to $750,000, and I'm going to order the bail increase in that amount because of the severity of the offenses involved and the possible penalties that the defendant faces. The court concludes in this case that cash bail is necessary. I'm not going to allow a bond to be used in lieu of cash. I will note, to the extent that the defendant's family has assets, they could, of course, borrow against those assets and obtain cash. I'm aware of that, but both because of the severity of the offenses and the possible penalties, primarily for that reason, the court is going to have bail remain at a cash figure, and the amount will be $750,000. Now, before we conclude today, counsel, I believe we're going back to one of the earlier motions. It appears we're going to need another motion date. I hope you brought your calendars with you. And Mr. Kratz, I didn't say it, but if you still intend to assure your motion to deny bail, I'm not going to start that at 10 minutes to 4 today. I think even though you may have witnesses here, I believe that the defense should have an opportunity to produce evidence of their own if they wish. I believe that they have under the statute, and I think they would be entitled to a specific notice that we're going to have such a hearing before we proceed. So I won't require you to make that decision today. Attorney Kratz, if I may suggest, Judge, if the court is going to be setting another motion, if the court would give me leave to provide the court with insufficient notice before that time to be heard that new time, or to withdraw my motion one way or another, I can alert the court that what I intend to do. The court, all right, counsel, you may be contemplating the filing of other motions that I haven't heard about today. So rather than me suggesting the date for you, I will let the attorneys tell me when you would like to meet next. I know there was going to be a defense motion relating to the complaint. Attorney Strang, yes. The court, and it sounded to me like perhaps something less than a month from now. Attorney Strang, I'm going to bring a motion relating to the right to a preliminary hearing on the 3 new charges, which the court has now ruled in denying bail or property bond are significant and add something. I guess for purposes of a preliminary hearing, I share that to a degree, and I had suggested that within 10 days. What I said earlier was from the court signing Mr. Kratz's proposed order that I can file a motion, but the fact is that I can do it 10 days from today. I don't need to wait for a written order since I understand the court's ruling. Court, all right. So you're going to file a motion within 10 days relating to any challenges you have to the amended complaint which the court today allowed to be filed. Attorney Strang, right. Say by the 27th, which would be 10 days, if that's acceptable. The court, Mr. Kratz, any objection? Attorney Kratz, no. At this time, I didn't know if Mr. Strang intended to include the issue of preliminary hearing. Attorney Strang, that is the issue. The court, yes, that's my understanding. Attorney Kratz, if I may also ask, Judge, I don't know if Mr. Strang believes that oral argument is required or if the court would be satisfied with just a written argument, my ability to respond, and then just your ruling. The court, are the parties willing to have that matter decided on written briefs? Attorney Kratz, that's fine, Judge. Attorney Strang, sure. And if the ruling goes our way, then we would have to do a telephone conference for purposes of scheduling preliminary, I suppose. Attorney Kratz, that's right. The court, I'm worried about things getting backed up. I would like to set a contingent date that you reserve on your calendar so that if something has to be done, it can be done. I don't want the calendar to get out of hand. I do have the entire morning of April 13th available. I would ask the parties how they feel about that. Attorney Strang, it's not an issue here, but for what it's worth, I know Passover begins on that day. I'm clear that day. Mr. Buting has to be in another circuit court in the state. Attorney Buting, Judge, at 1:30 I have to be in Waukesha on an oral argument. The court, all right. Attorney Buting, I suppose if it talks about it, if we broke by 11:30. The court, I think that would work. We could start at 9. Let me do this. I'm just going to hold that date for now. And depending on the motions that the parties file, if hearing has to be held, I would like to hold it on that date. I would also like to be kept informed by the parties' progress being made with respect to discovery and testing, so that if there are any motions that have to be filed, that they can be filed in a timely manner and I can hear them, so they don't jeopardize the September trial date. Attorney Strang, I don't want to sit on my hands here and not give the court fair warning, but I think it's at least possible with the March 1st, March 2nd developments, and now presumably further testing, much material and discovery that state can't disclose to us because it doesn't have it yet. I think September 5th trial date, this is questionable, very questionable. It's not a calendar problem for me. I just think that it's very questionable. And I can understand why the court would not want to move a date once it is set, So I don't want to sit here and sound like I'm acquiescing or raising at least a concern that for all the reasons that we have discussed today, the scheduling, like bail consideration, and what charges Mr. Avery is facing, all of these things may also have an effect on the trial scheduling. The court, Mr. Kratz, I don't know if you have any information yet about the timing of the testing that's going to be done. Attorney Kratz, on Monday, Judge, we meaning myself and the investigators involved in the case, intend to meet directly with the crime lab to get those answers. And so once we have a timetable, I would be happy to provide that to Mr. Strang and the court. The court, all right. Attorney Strang, the court's ruling on the motion concerning the fair forensic testing means that now necessarily the only avenue open to the defense would be sequential testing once the state's private testing is done. So that I don't know that we'll do that, but we may. That's what's left to us. Attorney Kratz, if it could be heard, we have offered what's already been tested already for retesting. The defense hasn't taken us up on that yet. We'll see if they do. That is already available for retesting. That decision should be able to be made before this new testing is done, Judge. Attorney Strang, that's absolutely true. As the stuff is seized in November, absolutely so, agreed. The court, all right. Is there anything else the either party wishes to take up this afternoon? Attorney Beauty, Judge, one other matter. When you mention other motions that we might need, we may be able to just short circuit that. If Mr. Kratz is willing to today, I could file a motion for the return of property. I'm informed that co-counsel has already spoken to the state and has reached some agreement on that, so that's fine. The court, all right. Anything else this afternoon? Attorney Kratz, no, Judge. The court, if not, we'll adjourn for today. Attorney Kratz, thank you. Attorney Strang, thank you. Proceedings concluded.